ಹಲೋ ಸರ್,
ಕೋರ್ಟ್ ಆಫೀಸರ್.
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಹೇಳಿ ಸರ್.
ಸೀರಿಯಲ್ ನಂಬರ್
ಡಿಕ್ಟೇಷನ್ ಮ್ಯಾಟರ್ ಇದೆಯಲ್ಲ ಅದೇನು ತಗೋತಾರ ಇಲ್ಲ ಸೀರಿಯಲ್ ಪ್ರಕಾರನೇ ಹೋಗ್ತಾರ ಸರ್?
ಒನ್ ಬೈ ಒನ್ ಸರ್. ಸೀರಿಯಲ್ ನಂಬರ್ ಹೇಳಿ.
ಸೀರಿಯಲ್ 94.
ಸೀರಿಯಲ್ ನಂಬರ್ 94 ಸರ್.
ಇನ್ನೂ ರೀಚ್ ಆಗಿಲ್ಲ ಅಲ್ಲ?
44 ಸರ್.
ಏನ್ ಸರ್?
44 ಸರ್, 44
ರೀಚ್ ಆಗಿಲ್ಲ. ಓಕೆ
ಸರ್, ಒಬ್ರಾದ್ಮೇಲೆ ಒಬ್ರು ಮಾಡಿ.
ಸರ್, ಯಾವ ಸೀರಿಯಲ್ ನಂಬರ್ ನಡೀತಾ ಇದೆ ಸರ್? 55 ಅಲ್ವಾ?
56
ಎಲ್ಲಾರು ಮಾತಾಡಿದ್ರೆ ಕೇಳಿಸಲ್ಲ.
ಸರ್ 44 ಏನಾಗಿದೆ ಸರ್?
ಸರ್ ಒಂದ್ ಸೆಕೆಂಡ್ ಸರ್, ನಿಧಾನವಾಗಿ ಒಬ್ರು ಒನ್ ಬೈ ಒನ್.
44 ಸರ್. ಸೀರಿಯಲ್ ನಂಬರ್ 44 ಸರ್. ಪಾಸ್ ಓವರ್ ಮೊದಲು ತಗೋತಾರ ಸರ್ ಸಾಹೇಬ್ರು? ಸರ್ 44 ಏನಾಗಿದೆ ಸರ್? ಸೀರಿಯಲ್ ನಂಬರ್ 44.
ಕೋರ್ಟ್ ಆಫೀಸರ್. ಕೋರ್ಟ್ ಆಫೀಸರ್. ಕೋರ್ಟ್ ಆಫೀಸರ್.
ಕೋರ್ಟ್ ಆಫೀಸರ್.
ಸರ್, ಲೈವ್ ಸ್ಟ್ರೀಮಿಂಗ್ ಹೋಗ್ತಾ ಇದೆ. ನೋ ಕ್ವಶನ್ಸ್ ಪ್ಲೀಸ್.
Lord, may I have one submission, my lord?
Yes,
Serial number 82, my lord.
yes.
I have some inconvenience, may be taken up tomorrow, my lord.
Serial number 82.
82 tomorrow. Tomorrow, my lord.
Tomorrow agalla. Thursday or next week?
Thursday.
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 10.
10th, Thursday also.
Yes, sir. 10.
82, serial number 82.
94.
82. Yes?
Serial number 94.
Yes.
Have it on next week, Your Lordship.
Serial number 94 at request of learned counsel for petitioner list this matter.
Interim order to be extended, Your Lordship.
17th. Interim order granted earlier if any is expressed in the next state of hearing.
Obliged.
Serial number 91, my lord.
Yes. The
I'm
sergeant.
appealing to respondent counsel, my lord. Now I am received the NOC wakalat, my lord. Now
2
you
weeks
have to
sergeant ಆಗಿದೆ. Sergeant by 2 weeks.
much obliged.
Serial number 38. The learned counsel for the respondent is held up in some function, so she could not able to attend the matter today. Therefore, she is seeking for a time.
30?
38, my lords. Your lordship has passed over in the morning that Geeta Devi Papanna.
39.
39. Sorry. My lord, may I request on my lord? 14th. My lord.
Petition will be, madam. 15th, 14th.
14th, please. Much.
My lord, 82, 10th ಅಲ್ಲ ಸ್ವಾಮಿ?
82 10th.
ಆಯ್ತು ಸ್ವಾಮಿ. Thank you. Much obliged, sir.
Lord, serial number 74, my lord, I am for the third respondent. I have a personal inconvenience. I request my lord to kindly have it tomorrow, my lord.
Number 74. 74?
74, my lord, I am for the third respondent.
Please inform other side.
I will.
At request of learned counsel for respond number 3, list this matter, madam. 16th.
Please.
Your Lordship, I am appearing for the petitioner in serial number 74 on behalf of A. Mahesh Chaudhary, Your Lordship.
It is urgent to 16th.
Your Lordship, it might be given tomorrow, Your Lordship. I'd move the matter because the construction is on Gale gas pipelines and there are almost 400 to 500 residents residing in.
Lakshmi Shri.
My lord, tomorrow is fine, my lord. I'll serve copy.
Tomorrow, brother. Friday, 11th.
Very well.
11th month.
Grateful, Your Lordship.
Grateful.
My lord, is it 17, my lord? So the 17, my lord?
17 is urgent.
Is my lord taking 55, my lord?
No, sir.
My lord, 17
Bill number 54, sir. 54.
Oh, I'm sorry.
But ಇದು ಬನ್ನಿ. The second respondent on credible information conducted the raid on 27/4/2019 on Night Queen Lounge Bar and Pub at 29/30 Lalbagh Fort Road, Minerva Circle, GC Road, Bangalore. And drawn the Panchanama and seized the sum of rupees 2,58,265 and arrested accused number 2 and 42 customer and 52 victim women. Stop. Thereafter, the respondent number 2 himself registered the crime? CCB. Thereafter, the respondent number 2 lodged a complaint with the first respondent against the petitioner and others for the offence punishable under section 103, 104, 105, 106, 31 of Police Act 1963 and sections 294 and 370 of IPC. To stop.
Thereafter, respondent number 2 lodged a complaint with the first respondent against the petitioner.
The first respondent registered the case against the petitioner for the offence, for the aforesaid offences. To stop. Being aggrieved by the registration of the FIR, the petitioner has filed this petition. To stop. Murthy B. Naik, learned senior counsel preparing for the petitioner submits that the petitioner is owner of the premises, sir. Is the first matter. Is the owner of the premises in question and the and is the owner of the premises in question and as such registration of the owner of the premises in question. However, the second respondent, without registering the FIR at the first instance, conducted the raid against the on the premises in question. And as such, the registration of the FIR and as such, the allegation made in the FIR does not disclose the commission of offences alleged against the petitioner. Hence, it submitted the FIR registered against the petitioner. However, registered against after conducting the raid is one without authority of law. So, in support of the submission, we have placed reliance on the. Which are the decisions we are relying upon? That is conducting raid without registering FIR. Reported in criminal pit. That is Lalita Kumari versus Government of Uttar Pradesh. That one. In support of his submission. We have placed reliance on the decision of the apex court in the case of Lalita Kumari versus Government of Uttar Pradesh and others reported in 2004 to SEC page 1. 2014. And which is the other one? Second one, that is Bajendra and fourth one. Second one is Bajendra. And in the case of State of Haryana and others versus Bhajanlal and others reported in 1992, supplementary 1, SEC 335, and the decision of the coordinated bench of this court in criminal petition number 5802 of 2016. These are the three decisions. On the first point. On the point of FIR not being registered prior to the. Then which is he further submitted the offences alleged against the petitioner. The allegations made in the FIR does not disclose the commission of an offence punishable under section. Trafficking. The offences punishable under section 294 and section 370 of IPC. In support, he has placed reliance on the decision of the apex court in the case of Indian Hotel and others, State of Maharashtra and others reported in 2019 PSSC 429. Stop. On the other hand, learned SCGP appearing for the response date to submit that the allegations made in the FIR clearly discloses the commission of offences punishable. This is the commission of offences and the FIR has been rightly been registered against the petitioner. I have examined the submission made in non-constitutional party. Admittedly, it is undisputed that the second respondent, without registering the FIR at the first instance, conducted the raid on the premises belonging to the petitioner, of which she is the owner, and lodged a written complaint with the first respondent for the offences punishable for the offences alleged against the petitioner. Stop. Relevant para in the first case, Lalita Kumar's case.
Relevant paragraph is paragraph 54 to 56 on page 31.
Where is it? Can you read?
Page 31, important paragraph 54 and 56.
But it is not obligatory on the officer of in charge of a police station to register the report.
The whole sentence is
Yes, yes.
it should be informed with us.
Hmm.
To publish that though it is the duty of every citizen to inform about commission of an offence, but it is not obligatory on the officer in charge of the police station to register the report. The word shall occur in section 39 of the code has to be given the same meaning as the word shall occur in section 1. Further not in para 83 on page 41.
Yes.
There you have this speak of the informant is a police officer.
Now, the apex court in the case of Lalita Kumar Sutra has held that conducting an investigation into an offence after registration of FIR under section 154 of the code is the procedure established by law and thus in conformity with Article 21 of the Constitution. Accordingly, the right of the accused under Article 21 of the Constitution is protected if the FIR is registered first and then the investigation is conducted in accordance with the provisions of law. Para 86. To stop. In the present case, the second respondent, without first writing, without lodging a complaint before the first respondent, has conducted a raid on the premises belonging to the petitioner and thereafter lodged a complaint to the first respondent against the petitioner and other accused for the offences alleged. Hence the registration of the FIR subsequent to conducting of the raid by the respondent number 2 is not permissible in law. Stop. That's the only ground. It is not permissible.
Not there, come from para 97 of the
Yes.
Para 97,
90?
Para 97.
Yes.
The code contemplates two kinds of FIR. The release and FIR, one is by the informant to the officer concerned. The second kind of FIR could be which is registered by the police itself on any information received or other than by the informant. And even this information has to be duly recorded and the copy should be sent to the magistrate for the registration of FIR either on the basis of information comment under section 154 of the code or otherwise under section 157 of the code is obligation. The obligation to register FIR has inherent requirements.
So it has been held in para 84. 86.
Furtherly, and what has been held is just because the informant is a police officer, not dispense with the registration of it.
The apex court in Lalita Kumar's case has further held merely because the informant is the police officer, but the registering of FIR cannot be dispensed with before conducting the raid, as held in para 97, which reads as follows. Next question. There is a complaint.
The complaint is that page 34. And there the second respondent says that he had valuable information on 24/9/2018. First line.
Yes, yes. That the allegation is that without there being any license. License.
That's the reason I had submitted in the morning. The reason for invoking the provision in the police act is he should only explain. I have license.
You have a license. The allegation in the FIR is that the other accused number Mataurashta is running the business. Allegation is that the accused were not possessed or not issued with a license. Was running the Night Queen lounge and bar, dance bar.
But I have also tried to translate a copy 36.
It is further the allegation in the FIR is that the petitioner without having the requisite license to run the dance bar, and brought women from across the country and forced them to indulge in vulgar dancing and used to utilize the money which the customers had given to the women who are indulging in dancing. It is undisputed that the accused number 2 is the owner of the dance bar. Accused number 2 was issued with the requisite license under the provisions of control order.
But it is the licensing and controlling of places.
Was issued with the license under the, please repeat it.
The licensing
The licensing
and controlling of places
The controlling of places
of public entertainment
in
bracket Bangalore City, bracket close, order 2005.
2005. Where is that license?
License I have produced.
Which is evident. 112. It is evident from the document produced at Annexure 12, which is a license. Allah.
It is the second petition, may I request the Lordship to kindly take 4421.
Yes, sir.
Annexure D, page 40.
It is evident from the
Document
license.
produced at Annexure.
Allah, which is evident from the license issued by the police. Dated
But it commences from Annexure D. The Lordship gets
Sir, that's what I put.
Annexure E, page 40.
It is undisputed in Bada. The petitioner is only the owner of the premises in question and was not involved in carrying on the and not carrying and was not involved in the petitioner, the owner of the petitioner, is the owner of the premises in question and then not involved in carrying on the business dance part, and the petitioner was also not present at the scene when the raid was conducted. So, in the absence of any such incriminating material, proceeding against the petitioner is misconceived and the same requires to be quashed. The registration of the FIR against the petitioner after conducting the raid is one without authority of law, and the petitioner is no way concerned with the business of running dance bar by the accused number 2. The registration of the FIR against the petitioner is not sustainable in law. Accordingly, I pass the following. New petition is allowed. The intent first information report registered in crime number 0081 of 2019, dated 28/4/2019, by the Kalasyapalya Police Station, Chitpet Subdivision, Bengaluru City, pending on the file of 8 ACMM, Nirpatanga Road, Bengaluru City, for the offences punishable under section 103, 104, 105, 106, 31 of Karnataka Police Act 1963, and sections 294 and 370 of IPC is hereby quashed.
Pardon, my lord, with your lordship kind permission, serial number 17 in the morning, it has been passed over, my lord. At 2:30, VC was not connecting. I came, my lord. Interim order expressed today, my lord. Serial number 17. I am for the petitioner. Morning, respondent number 2 advocate has not appeared when my lordship has called the matter, my lord.
Just wait, I'll take it up.
Yes, ma'am. Yes, ma'am.
Petition 4421. On receiving credible information, the second respondent on 27/4/2019 conducted a surprise raid on the Night Queen lounge bar and pub in the premises belonging to the accused number two, and thereafter drawn the Panchanama and seized the sum of rupees 2,58,265 and arrested accused number one on that, and arrested the petitioner and other accused, and so also 42 customers and 52 victim women, 52 women. Full stop. Thereafter, the full stop. Thereafter, the paramount. Thereafter, the second respondent filed written information with the first respondent against the petitioner and other accused for the offences punishable under sections 103, 104, 105, 106, 31 of the Karnataka Police Act 1963 and sections 294 and 370 of IPC. The first respondent registered the first information report against the petitioner and in FIR number in crime number 0081 of 2019, being agreed by the same petitioner as well as petition to stop same learned to counsel for respond this ones or else one paragraph I will report. The petitioner was issued with the license. Where is that license? Second petition. The petitioner was issued with the license. Was issued with the license in form number 3. Under the license and controlling of place of public entertainment for keeping a place of public entertainment, which is evident from document produced as an actual. So, the apex court in the case of citation. Mr. Naik, which is the judgment Supreme Court which says that it does not constitute commission of offense or trafficking?
That is Indian hotels.
Indian hotels. The apex court in the case of Indian Hotels and Restaurant Association Supra. have held that. Have held that. Have held that the state neither had the empirical data to conclude that dancing in the prohibited establishment necessarily leads to depravity and corruption of public morals, nor was there general consensus that such was the situation. Which is the relevant para? 80.2.
Yes, 80.1 onwards and 80.2. But 80.1 only. They have accepted the earlier judgment.
Yes, yes.
2030. This is 2019.
Yes, yes.
In 80.2, they have accepted paragraph.
Ratio analysis by the apostle in the case of Indian hotel sector, the allegations made in the FIR does not constitute the commission of offence punishable under human trafficking is 290 to 370. 370 does not constitute the commission of offence punishable under section 370 of the Indian Penal Code. ಇದೊಂದು ಇದೆಲ್ಲ ಅದನ್ನ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಇದರೊಳಗೆ ಅದ ಬರುತ್ತೆ accordingly a perfectly so the new petition below.
I am appearing for the counsel for the petitioner. 55. The matter arises under the Factories Act. But the case is,
yes, sir.
The inspector of factories, he visited the establishment, found in Tata Tea that some of the noise levels of the machine were high, and some of the workers had hearing capacity has been affected. He wanted some tests to be conducted. We can send the matter to the laboratories for testing all the workmen. The test was conducted, and it was found not all the workmen have been having, one or two people have got some affection of the hearing. Now what has happened is the factory factory has been closed on 13th March 2021. All the employees have been paid compensation, they left services. The two accused have also retired from service. Only I am requesting, my lord, page number 97, your lordship may have a look at it. Page number 97.
Yes, sir.
The inspector, though says that I have committed offense and all those things, he says it is liable to be fined and the baritare. Last paragraph. Julmane anta. Page 97.
Yes,
So,
sir.
my lord, my clients, my lord, they accused are praying that they may be, they are pleading guilty. Your lordship may levy some fine and close the matter because the matter has been pending for a long time. They have retired from service. All the workmen have left the services. Nobody is affected. And a similar matter, my lord, your lordship, my lord, this court in criminal petition number 1446 of 2016, dated 23rd December 2019, his lordship Justice Kunna had passed a similar order imposing a fine and closing the matter, my lord.
What is that order?
Yeah, this is the order is here, my lord. I have not circulated it.
Yes, sir. Case number, sir?
Case number, my lord, 1446 of 2016, criminal petition, 1446 of 2016, order dated 23rd September 2019. Since it's a summons case, the pleader can plead guilty, and we have been instructed, if your lordship means, since the inspector himself says we should be levied some fine, your lordship may levy some fine and close the matter, my lord. Your lordship pleases.
ಫೈನ್ ಹಾಕಿ ಇದು ಮಾಡಿ ಅಂತ. Yes, sir. Disposal of in terms in light of the order passed in the similar matter.
Much obliged. But fine, your lordship may keep in mind, not too much. They are all retired.
What is the maximum fine?
2 lakhs, up to 2 lakhs.
2 lakhs. What is the fine imposed in the other case, sir?
I would.
Yes, sir, 50,000.
25 marks fine. Good is there.
50,000, sir, from 2 lakh to 50.
25 each mark.
25 each. 25 each. Total 50. Here, find the complaint.
ಇಲ್ಲ 1 lakh ಇದೆ, except 1 lakh. Section 92 is 1 lakh ಅಂತ ಇದೆ.
Okay, sir. Filed a private complaint under section 200 CRPC against the petitioner for the offences punishable under section what are the offences, sir?
Section 92 of the Factories Act.
92 of the Factories Act.
And the column under Factories Rules, rule number 99.
And rule 99.
89 and 99.
89 and 99 of the
A. Or Karnataka Factories Rule. Page number 97.
Section 92 of the Karnataka's Factories Act 1948.
And Factories Act ಅಷ್ಟೇ ಕರ್ನಾಟಕ ಅಲ್ಲ, Factories Rules Karnataka.
The Factories Act 1948 and rule
89 and 99A.
89 and 99A of the Karnataka Factory Rules. The jurisdiction alleging that the
96 ಅಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ, ಉಲ್ಲಂಘನೆ ಹೇಳುವಂತ ಹೇಳ್ಬಿಟ್ಟು ಮುಂದುವರೆದು ಆಲ್ ಇಂಡಿಯಾ ಸ್ಪೀಚ್ ಅಂಡ್ ಸೋಲ್ಸೋ ಇಂದಿನವರೆಗೂ ವೈದ್ಯಕೀಯ ಪರೀಕ್ಷೆಯಲ್ಲಿ ಬರುವ ಕಾಯಿಲೆಗಳನ್ನು ಕಾರ್ಖಾನೆ ನಿಯಮ ಸೋನ್ಸಂತೆ ಮಾಡುವುದು ಅಥವಾ ಇವುಗಳನ್ನು ತಡೆಗಟ್ಟುವ ಬಗ್ಗೆ ತಾಂತ್ರಿಕವಾದಂತ ಸೋನ್ಸು. ಅದೇ ವಿ ನಾಟ್ ಟೇಕ್ ಆಕ್ಷನ್, ರೆಮಿಡಿಯಲ್ ಆಕ್ಷನ್ ಅಂತ ಹೇಳ್ತಾರೆ. 96 ಪೇಜ್ 96 ನಲ್ಲಿ ಉಲ್ಲಂಘನೆಗಳು ಅದು ಕೆಳಗಿದೆ.
Yes. Alleging that the noise level in the factory is on the higher than the.
No, workers were not given proper treatment and it has not been done ಅಂತ ಹೇಳ್ತಾರೆ.
Workmen were not given proper treatment.
ಯಾವುದೇ ಕ್ರಮವನ್ನು ತೆಗೆದುಕೊಂಡಿಲ್ಲ ಅಂತ ಹೇಳೋದು. We have done it. ವೈದ್ಯಕೀಯ ಪರೀಕ್ಷೆಗಳಿಗೆ ಬರುವ ಕಾಯಿಲೆಗಳನ್ನು ಕಾರ್ಖಾನೆಗಳ ನಿಯಮದಂತೆ ನೋಟಿಫೈ ಮಾಡುವುದು ಅಥವಾ ಇವುಗಳನ್ನು ತಡೆಗಟ್ಟುವ ಬಗ್ಗೆ ತಾಂತ್ರಿಕ ವಿಧಾನದಿಂದ ಅಥವಾ ಬೇರೆ ಯಾವುದೇ ಕ್ರಮವನ್ನು ತೆಗೆದುಕೊಂಡಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. Only a few workers have been found to be having some defect. So one page complaint at 96 million.
Yes, sir.
Under 92, it is 1 lakh. Fine.
It is 1 lakh.
Good. Which may extend to 1 lakh rupees. And canteen workers ಗೆ ನಾವು medical examination ಮಾಡಿಲ್ಲ ಅಂತ.
Filed a private company for often alleging that are not notified with the appropriate authority with regard to the hearing problem of 83 workmen out of 153 workmen, and not taken any measure for preventing
Corrective actions.
corrective measure has not taken any corrective measures for preventing the disease.
ಅದು ಕರೆಕ್ಟ್ ಮಾಡೋದಕ್ಕೆ ಬರೋದಿಲ್ಲ actually. In fact, our noise levels are within limits. As per page number 87. ಆ ಕಾರ್ಖಾನೆ ಕ್ಯಾಂಟೀನ್ ನಲ್ಲಿ ವರ್ಕರ್ಸ್ ಗೆ ಮೆಡಿಕಲ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡಿಲ್ಲ ಅಂತ ಎರಡನೇ ಅಲಿಗೇಷನ್ ಪೇಜ್ 97 ನಲ್ಲಿ. ಕಾರ್ಖಾನೆ ಉಪಹಾರ ಗೃಹದ ಕಾರ್ಮಿಕರಿಗೆ ಕಲಂ 99A ಪ್ರಕಾರ ವೈದ್ಯಕೀಯ ಪರೀಕ್ಷೆಗಳನ್ನು ಮಾಡಿಸಿ ವರದಿಯನ್ನು ನಿರ್ವಹಿಸಿದೆ. ಇದನ್ನು ಮಾಡದೇ ಇರುವುದರಿಂದ ಈ ಒಂದು ಉಲ್ಲಂಘನೆ ಆಗುತ್ತೆ. Your lordship will be passing separate orders, no?
Yes, sir, I'll allow that. I'll look into that, go through that order and pass orders.
Much obliged. I'm sorry because I should have filed a cancellation, but
No, no, it's fine.
ಸ್ವಲ್ಪ technical ಆಗಿದೆ.
ಆಯ್ತು.
Much obliged.
Serial number 57, my lords.
Yes, yes.
Please. Serial number 57, a limited prayer is sought for, whereby the petitioner accused number 1 to 4 are seeking for quashing off only section 9, 27, 31, read with 51 of the Wildlife Protection Act. My lords, SC number 56 of 13 is pending as against accused number 1 to 4. For the offense under 302, 323, 324, 506, read with 120B.
What is the limited prayer?
May I go on, my lords?
On the other side, learned SCGP is paying for time to get instructions.
Allah, it's a very limited prayer of only Wildlife Act.
Only Wildlife.
Let the 302 case go on. The 302 case may go on. Wildlife Act, there is a bar under section 55 of CR 55 of Wildlife Act that no cognizance can be taken.
I said one. Yes, yes. What does it say? Section 55. Section 55
says, no court shall take cognizance of any offense against this act except on the complaint of any person other than so and so. Other than on a complaint, cognizance of offenses under the Wildlife Protection Act cannot be taken. Such being the case, the other offenses of 302, 323, 324, 120B can go on, and Arms Act can go on. But the offenses under the Wildlife Protection Act cannot go on because the same is covered by the decision of this honorable court in criminal petition number 6279 of 17. 6279 of 17. There, 379 and acts under the MMDR Act were invoked.
Yes.
MMDR Act has a similar ban under section 22 of the MMDR Act that no offenses can be tried apart from on a complaint by the person. Now the complaint and as defined under section 2D of CRPC means a private complaint. So they quashed the MMDR Act and let 379 go on. The IPC offenses trial can go on. Arms Act trial can go on. Only the Wildlife Protection Act I am seeking for quashing.
So only the persons who are specified in section 55 can lodge a complaint.
Please. Complaint as defined under section 2D is a private complaint.
The written baraalla. Allah, he only seeking for quashing of the offences raised punishable under the provisions of Wildlife Act. ಅದು ಸಪರೇಟ್ ಮಾಡ್ಬೇಕಾಗತ್ತೆ. The 55 code written complaint by the persons who are specified in section 55. So to that extent is seeking for quashing. At request of Lord SCGP, list this matter. When do you want? 22, what do right? 17th. 17th.
Well, as the interim order may be granted.
Order granted earlier if any, let's see till the next date of hearing. Yadav? 58. At request of Lord Council for respond number 2, list this matter next week. Interim order granted earlier is extended till the next date of hearing.
Yes.
Date ಕೊಟ್ಬಿಡಿ madam. Bill number 58. 22nd.
The petitioner is narrated as an accused in one. The section 306 of IPC and accused of 49. 306.
306. Yes.
This ballot. The complainant files in a FIR. On investigation, they files in a investigation officer files in a P report. The P report was challenged by the complainant, and they proceeded with the objections as well as the complaint.
Yes.
And based on the objections in the complaint, the London magistrate comes to the conclusion, and when you look into the page 86, 86, there are furnished, there are ownership, that the Adesha.
Yes, yes.
Adesha, Arupikaru, Viruddha Bharatiya Danda.
So B report was rejected.
No. There is no question, there is no word of rejection here. It should be either rejected or accepted. We have decisions on that point. And here the London magistrate has not rejected or accepted.
Procedure-
He proceeded to issue marks.
Procedural irregularity.
Please, madam. That's the only question here.
Matter has to be remanded.
Please, I so grateful. The complaint, I like the complaint of the notes, so we can put it to the
First respondent.
complaint. Other issue is not.
Grant interim order. Issue emergency notice to first respondent. Learned CGP accept notice for respondent number 2 for the proceedings in CC number 3767 of 2018, pending on the file of second additional Chief Metropolitan Magistrate, Bengaluru State until further orders. This matter immediately after service of notice. Hogilvalla.
Appearing for the petitioner in this matter, my lord.
Yes.
Offense under 341, 354, 504, that is wrongful restraint, outraging the modesty of women, my lords, and that too kidnapping the child, my lords. The complaint is dated 3rd February 2008, my lords. As on that day, my lords, petitioner is an employee of State Trading Corporation. He was not in Bangalore itself, my lords. That is produced by the communication given by page 63, my lords. Page 63, my lords. This is given by State Trading Corporation of India, Government of India undertaking. This is to certify K. Srinivas, who is the petitioner before your lordship, representative of STC Employees Union on 3rd February. Complaint is 4th February, my lords. 3rd February to 6th February for 4 days to attend the joint consultative.
Date of complaint? Incident?
4th February, 6:30 a.m.
Date of incident?
4th February, 6:30 a.m. in the hotel, so and so, and was sanctioned as per the head office of State Trading Corporation of India at New Delhi. Instructed date was 11th January. It was much before 11th January. Was instructed by State Trading Corporation at Delhi to go to Chennai on 3rd February. He has submitted TA bills and have produced all the documents, page 64, my lords, why he went, and page 65, my lords, he had gone along with 27 people. Petitioner's name is at page 65, serial number 23. At page 55, my lords. List of participants of JCC to be held on 4th and 5th February. Serial number 23 is the petitioner. Then this is, my lords, the communication given by fax communication by Delhi, my lords. This page 67 is important, my lords. I may permit you to read that. Page 67.
Yes, sir.
The meeting between CWC of so and so and the management is fixed on 4th and 5th February 2008. You may please relieve Srinivas petitioner from your branch to enable him to participate in the meeting. Reservation may be so arranged that he should reach Chennai on 2nd evening but 3rd February 2008 morning for the internal meeting on 3rd February 2008, and his return journey may be booked for 6th February. So they have done all the booking, my lord, the State Trading Corporation, and accordingly I've gone, my lord, and I produced the State Trading.
What is this husband and wife?
not husband and wife, my lords. She had petitioner has entered into a joint development agreement with the property in question. She claims right over the property, my lords. She has also filed a suit at page 124, my lords, against the erstwhile owner of the property, claiming right over the property. The suit has been dismissed. Now, because the petitioner has taken the property in joint development, my lords. Yeah.
So what is the relationship between petitioner and the informant?
No relationship, no, absolutely no relationship, except that he's taken the land on joint development, which she claims she has a right, my lords. She's claiming right over a property in question, my lords.
Under what? As an owner or?
As being a relative of the original owner. That I'll point out, my lords. Your lordship may kindly see that at page, the gift deed I produced. Your lordship may kindly see the gift deed at page number. Page number annexure E, page 52, my lords. The property in question belonged to Srimati Yashoda, my lords. She gives the property to Vaga Devi, page 52, annexure E. This is in the year 2006, my lord. In 2007, she files page 124, my lord. She files OS number 1644 of 2007, page 124. The complainant at page 124 files the suit for injunction against the erstwhile owner Yashodamma and others, my lord. The injunction suit came to be
totally 3 accused: the petitioner, Shashi, and Siddesh.
Please, my lord. I am only concerned with Shashi Srinivas, my lord.
Yes.
Who is an employee of State Trading Corporation, my lord. And he was not in Bangalore itself, my lord. The document given by undisputed document given by the government of India undertaking that STC shows that I was in Chennai along with 27 other people. It is an all India meeting, my lord. And they have booked the tickets. I have produced the ticket copies. In fact, the respondents have been served, court had asked us, they served and unrepresented also, my lord. And
what has happened to OS number 1644 of 20?
Dismissed for non-prosecution, my lord. That your lordship will get it at.
It is filed by the informant.
Correct. Complainant, my lord.
Complainant against the petitioners.
Not against the petitioners and the original owner. I pointed out the gift deed, my lord.
Yes, there is no suit filed against the petitioner.
No, my lord.
Your synopsis says that 1644 of 2007 against the petitioner and others with respect to so and so.
Please, I'm sorry, my lord. And others, I'm sorry. At page 27, Yashodamma and others. Page 124. I'm sorry, my lord. I'm correct. Even in the complaint, she refers to the said suit, my lord. 644 of 2007. In the complaint itself, my lord, that has been referred to at page number 25. 23, my lord. For annexure A.
Yes. We are not in station. Those documents have not been controverted. Revolver on 20? 24. Ready. No. ಇಲ್ಲಿದೆ revolver. Stay ಏನಿಲ್ಲ. First point lodged a first information report alleging that on 4/2/2008, when she was walking alone on Nagawara Palya Main Road, the petitioner and two other accused stopped her, weighed her, impeded her, caught hold of her hand, dragged and pulled her, and abused her with filthy language and threatened her with dire consequences if she did not withdraw the OS number 16444 of 2007. It was further alleged that her children will be kidnapped and they have got political clout, and the petitioner herein showed a revolver to the informant. To stop, the jurisdictional police registered the FIR against the petitioner and two others for the offences punishable under 341, 340, 354, 504, 506, read with section 34 of IPC. To stop. Being aggrieved, this petition is filed. Shashikiran Shetty, Senate Senior Counsel, appearing for the petitioner, would submit that as on the date of incident, the petitioner was on an official trip to
Chennai,
from
3rd February to 6th February.
3/2/2008 to 6/2/2008. To stop. Hence, the FIR registered against the petitioner for the offense for the alleged incident which occurred on 4th February 2008.
Hence, FIR registered.
Hence the FIR lodged by the first respondent is with an intention to falsely implicate the petitioner. Since he submits that the impugn FIR registered against the petitioner is not sustainable in law. Stop. In on the next submission.
Manoj, her other thing is we have threatened saying that we'll kidnap the children, Manoj. In fact,
that is that covers your first ground that you are not there in Bangalore as on the date of.
This complaint has been filed as a counter blast to resolve the dispute, Manoj, because she has filed a suit OS number 1644 of 2007. She was not able to get an injunction, Manoj. In order to prevent us, this false complaint has came to be lodged. Because her case, Manoj, we have threatened her to withdraw this suit. She has not got any interim order to withdraw, Manoj. Subsequently, the suit was also dismissed. So therefore, question saying that to threaten her to withdraw does not arise.
You are the owner of the property.
Not the owner, Manoj, but we have taken the property for development, Manoj. She has filed against the owner also, that is Yashodamma. Your Worship will get it at page.
That the informant having not obtained an order of restraint against the petitioner and others in OS number 24 in OS number 1644 of 2007 as a counter blast has filed the FIR against the petitioner and others. On the other hand, Learned CGP appearing for the response state to justify the FIR registered against the petitioner and others, having regard to the fact that the allegations made in the FIR discloses the commission of offences as alleged against the petitioner. Stop. I have examined the submission made by the parties. The alleged incident has taken place on
4th February at 6:30 a.m.
4th February 2008 at about
6:30 a.m.
6:30 a.m. The petitioner has produced documents to substantiate his claim that he was on an official trip to Chennai from 3rd February 2008 to 6th February 2008.
Please.
Respondent has not controverted the documents produced by the petitioner to substantiate that he was not present, that was not in Bangalore as on the date of alleged incident. The genuineness of the said documents having not been denied by the first respondent, it is implied that the petitioner was on an official trip from 3/2/2008 to 6/2/2008, and he was not present in Bangalore as on the date of alleged incident.
Including the train ticket, Manoj, including the train ticket.
Documents, all the documents.
Please.
The documents produced. Hence, it is implied that it is implied that the first respondent has lodged the first information report against the petitioner, has lodged the first information report so as to falsely implicate the petitioner for the offences alleged. In view of the same, the impugned FIR registered against the petitioner requires to be quashed. Accordingly, across the following, no petition is allowed. Charge sheet ಆಗಿದೆಯಾ?
ಆಗಿದೆ Manoj. That is prayer B, Manoj.
Police after investigation.
On 29/11/2008, Manoj, immediately they have filed the charge sheet also.
Revolver. Shashikaran, whether the revolver belonging to the petitioner has been seized still.
Nothing, Manoj. Your Lordship may kindly see, FIR is dated February. Within 6 months, they have filed a charge sheet, 2008. We came to know only in 2015, Manoj. Nothing has been seized, no material in the charge sheet also, Manoj.
It is relevant, to state here that the police, during the course of investigation, has not recorded the statement of the petitioner and other accused and not seized the revolver alleged revolver belonging to the petitioner.
It is implied that to the question.
Falsely implicated. Accordingly, past the following, new petition is allowed. The proceeding in CC number 2215/7 of 2009, pending on the file of 10th ACMM at Bangalore, for the offences punishable under section 341, 354, 504, 506, and 34 of IPC. In so far it relates to the petitioner, is hereby quashed.
I'm grateful to Manoj.
Again, file of private complaint under section for alleging that so and so money.
One were not given
Proper treatment and
He has not
they were not subjected to medical examination. And the petitioners did not furnish the report of the medical report. Did not furnish the medical report. Learned Senior Counsel appearing for the Kasturi, Learned Senior Counsel appearing for the petitioners submits that the factory itself is closed down and intimation in this regard is served on the authority specified and the petitioner has decided to plead guilty of the alleged offences and it is the power and it is within the power of court under section 482 of CRPC to permit the parties to compound the alleged offence and thus sought to accept the plea of the petitioners and to pass appropriate order in terms of section 92 of the Act. The learned SCGP appearing for the state submitted that having regard to the circumstances of the case, the petitioner be directed to approach the trial court so that the trial court would pass appropriate order on their plea. I've considered submission made to the learned counsel for the parties. The factory run by the petitioners having been closed down and the petitioners having pleaded guilty of the charges alleged by the respondent, he could serve the ends of justice if the plea of the petitioner is accepted and he is sentenced to terms is sentenced in terms of section 92 of the Act. Accordingly, the petitioners are held guilty of the contravention of section 92 of the Karnataka Factory Rules 1959 and sentenced to pay a fine of rupees 25,000 each for the alleged violations punishable under section 92 of the Act. The said fine amount shall be deposited before the trial court within a period of 6 weeks from the date of receipt of the certified copy of this order, failing which the petitioners shall serve imprisonment for a period of 6 months. Petition accordingly disposed of in terms of the above order. This order having been passed under peculiar circumstances, shall not be treated as a precedent under any circumstance.
Serial number 61.
Picture bill. The next survey. What is the next survey? Income and caste certificate.
Yes, that's certificate and income certificate. Based on that order, the worship, the affair was registered. This case is a worship.
ನೈಜತೆಯಿಂದ ಅಂದ್ರೆ it is not ಇಲ್ಲದೆ ಇರೋದು ಮತ್ತು ಅಂದ್ರೆ by furnishing false information you have secured the caste or case. The allegation is that the petitioner by giving false information has obtained income and caste certificate. False information. And now the FIR is registered. What? Under what provision?
Under provision of the
466. Other fabrication of document.
Back with the irrigation anonymous letter, the affair was registered at the first instance. That has been your worship. The commissioner of police or worship anonymous letter and the affair registered. For the clarification from the jurisdiction of Tahsildar, Duration Tahsildar your worship, we will not such a birth certificate and income certificate as an obtained. So that I can obtain the part to that effective worship, the report of the insurance order and credit. The call for report from the Tahsildar.
Now, what is wrong with the registration? I come there is an order by the rightly or wrongly an order is passed. This has attained finality, no?
Now it is now they are challenging because of that only I had challenged.
All right, 23/11/2016 order passed by the assistant commissioner.
Yes, that is why I have challenged you, worship. That is that we challenge election A. Election A, attendance order. Based on that, the affair was registered.
What is the ground of challenge to this?
Ground of challenge is worship now.
ಅಲ್ಲ ಇದ್ರ ಮೇಲೆ ಅಪೀಲ್ ಇದೆ ಅಲ್ಲ ಇದು.
ಅದೇ ground ಮೇಲೆ appeal ಇದೆ. Moreover, your worship now, your worship is kindly referred to. Before the proceedings before the assistant commissioner of your worship, what
ರದ್ದುಗೊಳಿಸಿ. ಅಲ್ಲ Bandari, Annexure A order is an appealable order. ಅಲ್ಲ that is independent. ಅದು ಇದು ಬೇರೆ ಆಗುತ್ತಲ್ಲ. It is an appealable order. Unless you establish that the order is one without authority of law. Nub madak barla. Challenge Annexure A also. Annexure A. Annexure
J. Orders being created by the assistant commissioner was just on the report of the Tahsildar.
This is appealable, Mr. Bandari.
Mr. J. Mr. J.
Yes.
Mr. J. Next what 400 page. Page 400.
ವಾದಿ ಪ್ರತಿವಾದಿ ಹಾಜರಿದ್ದರು ಪ್ರಕರಣಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ
ವಾದಿ ಪ್ರತಿವಾದಿ ಹಾಜರಿದ್ದರು ಪ್ರಕರಣಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ತಹಶೀಲ್ದಾರ್ ಸಲ್ಲಿಸಿದ ವರದಿಯನ್ನು ಪರಿಶೀಲಿಸಿದ ಮತ್ತು ಸಲ್ಲಿಸುವ ಮೂಲ ದಾಖಲೆ ಪರಿಶೀಲಿಸಿದ ಪ್ರತಿವಾದಿ ಹಾಜರಿರುವುದಿಲ್ಲ ಪ್ರತಿವಾದಿ ಕಾಲಾವಕಾಶ ನೀಡಿ ಶುದ್ಧ ಮಾಹಿತಿ ನೀಡಿರುವುದಿಲ್ಲ ಪ್ರಕರಣ ಪರಿಶೀಲಿಸಿ ತಹಶೀಲ್ದಾರ್ ಶಿವಮೊಗ್ಗದಲ್ಲಿ ಪ್ರಕರಣ ಹಾಜರಿರುತ್ತಾರೆ ಹಾಜರಾಗಿ ಪರಿಶೀಲಿಸಿದೆ. Now, the person is referred to the How does it? You have present and you have made an application to go. Unless the cross-examine the customer who gave the report, that is Mr. H, who comes in. Despite making such an application, cross-examine the customer, you submitted a report to the assistant commission.
But order sheet says otherwise. Generally, see like this application was filed to cross-examine the complainant petitioner therein. How to believe this application?
The application also the local what it has been submitted. Open because authority. Then order sheet has signed there. Order sheet has been particular. Okay. Then you was to the
That's point number 1.
Ultimate work by solution worship, which is if they have wanting to the issues to worship what I wanted to pass on to the customer, then would have been given the opportunity of even in my case.
But appealable order is there. An appeal is provided under the Act. So far as annexure is concerned, it is an appealable order.
But the next step, I have listed with the FIR.
Let us see the FIR.
This case was fine. The FIR was fine. And then there was no benefit.
E.
Whatever it is open to the response date to initiate the appropriate proceedings. What my submission was if there's any past verification in terms of was we appear under past assumption or past application was past information that has been verified by past verification committee. That's the verification committee. Past verification committee was. Unit money was not on ground. SST. No, I have done.
What is it? Yeah, and what provision of law this order has been passed? Mr. Bandari, which is under what provision of law this order at annexure is passed?
Minister here does not say what provision it is accepted. One is the also in the page number 18 of the
Section 4.
Karnataka ಅನುಸೂಚಿತ ಜಾತಿಗಳ ಅನುಸೂಚಿತ ಗುಣಮಟ್ಟವನ್ನು ಹಿಂದುಳಿದ ವರ್ಗ ನೇಮಕಾತಿಗಳ ಉತ್ತರದಲ್ಲಿ ವಿಸ್ತರಣೆ ಅಧಿನಿಯಮ 1990 ಅದರ ಸಂವಿಧಾನದ ನಿಯಮಗಳ ಹಾಗೂ ತಿದ್ದುಪಡಿಗಳ ಸೆಕ್ಷನ್ 4 ರಲ್ಲಿ 4 ಡಿ ರಿಟರ್ನ್ ಮೆಸೇಜ್ ಪುರಸ್ಕರಿಸಿದೆ ಸರ್ಕಾರವು ಉಪಯೋಗವಾಗಿದೆ. The last identification committee is a person under section 4 of the Proceedings. There are some which district issued elected by persons which is the committee shall consist of 4 members, the deputy commissioner of the district school secretary chairman, the deputy secretary administration officer, the Tahsildar of the town, the district social welfare officer of the member of the secretary. The cost verification commission constituted under the CST and other backward cost. Thus, reservation and appointment of the rules and people. That is not much to the level.
Under the rules, Rule 7A, it is only the Directorate of Civil Rights Enforcement who can lodge the complaint. DCR power. Who's got the power to cancel the caste certificate? It is only the section 4C ಕೆಳಗೆ verification committee who can cancel the caste certificate. 4A ಕೆಳಗೆ 4C. No, section 4C1. 4C. 4C of the Act, Karnataka SC/ST and other backward class reservation of appointment, etc. Act, section 4C note. Other two, subsection 2, any person. Other subsection 2.
Any person who has obtained the caste certificate or any interim caste certificate under section 4 or 4 may make an application to verification of such or research land as verification committee. Now rules never looked at that. Rules as verification committee rules 1992.
Take one. Rule 7. Rule 7.
Rule 7, your worship.
3.
Issue of right certificate.
Allah, if subsection 3, sub rule 3. But where the committee finds that the applicant obtained the false caste certificate or by making a false representation, he shall pass an order rejecting the application, indicating the reasons thereof for such.
Ultimately, committee has to verify it. The state council has no power to.
How did, on what basis the assistant commissioner took cognizance?
Because of the Tahsildar has filed the report.
Tahsildar.
This was beyond.
So section B, 4B, it has been passed. 4B kelige, it is any person aggrieved by an order of Tahsildar under section 4A may within 30 days file an appeal before the assistant commissioner. The Tahsildar himself has filed an appeal, not maintainable. Tahsildar ಮಾಡಿದ. He cannot maintain. I'll just give dictation and give text. The was issued with the petitioners were issued with the caste certificate or income and is on. According to you?
According to them, not obtained your worship. Because we are not obtained, we are not any benefit of that.
28, paragraph number 3rd paragraph. Like, ಈ ಎಲ್ಲ ಅಂಶಗಳ ಪರಿಶೀಲನೆ ಸಮಿತಿ ಅಂತಿಮ ಪೊಲೀಸ್ ಆದರೆ ತಮ್ಮ ಮಗಳ ಸಲ್ಲಿಸುವ ಸದರಿ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ದಾವಣಗೆರೆ ವಿಳಾಸ ತಂದೆ ಜಿಲ್ಲಾ ವೃತ್ತಿ ಕೃಷಿಕವೆಂತಲೋ ತಾಯಿ ಅಂಜುಮ ಬಾನು ವೃತ್ತಿ ಗೃಹಿಣಿ ಅಂತಲೋ ಸುಳ್ಳು ಮಾಹಿತಿ ತುಂಬಿರುವುದು ಸದರಿ ಅರ್ಜಿನಲ್ಲಿ ತಿಳಿದುಬರುತ್ತದೆ. ಆದರೆ ಭರ್ತಿ ಮಾಡಿರುವ ಸದರಿ ಒಂದು ವೇಳೆ ಸ್ವೀಕರಿಸಿದ ಬಗ್ಗೆ
The fourth respondent alleging that the petitioner had obtained a false income certificate. The fourth respondent alleging that the petitioners had obtained a false income certificate and had tried to obtain scholarship for the daughter and a seat in professional college on the basis of the said income certificate, filed an appeal before the second respondent for cancelling the caste certificate issued by him under section, filed an appeal under section 4B of the Karnataka SC/ST and other backward classes bracket open reservation of appointment etc. Act bracket close Act 1990. Stop. The second respondent by impugned order dated 23/11/2016 cancelled the income and caste certificate issued in favor of the petitioner and further directed the Tahsildar to take appropriate action in accordance with law. Stop. Is the complaint is lodged by informant ಇರ್ತಾರಲ್ಲ ಯಾರು anonymous on an anonymous complaint the jurisdictional police lodged registered the first information report against the petitioner in crime number 222 of 2016 for the offences punishable under section
this FIR was registered based on annexed again.
Just 5A 6A of the Karnataka SC/ST and other backward classes bracket open reservation of appointment etc. Act 1990 and under section 465 468 471 34 of IPC 1860. Stop. Being agreed by the same, the petitioner before this court. Learned counsel appearing for the petitioner submits that the impugned order passed by the second respondent cancelling the income and caste certificate issued in the favor of the petitioner is one without authority of law, since the authority prescribed to cancel the caste certificate is a committable. Since the power to cancel the caste and income certificate is vested with the verification committee. Is vested with the caste and income verification committee as specified under Rule 7 of the Karnataka Rule 7 of the Karnataka SC/ST and other backward classes bracket open reservation of appointment etc. Rules 1962. He further submits that the FIR registered on the basis of anonymous letter is also one without authority of law, since it is only on the complaint is only on the first information lodged by the Directorate of Civil Rights Enforcement as specified under Rule 7A of the rules the jurisdictional police can register the FIR against the petitioners. DCRE is Rule 7A ಕೆಳಗೆ Rule 7A. Copy of this. Only he can lodge the FIR. Other. One appeal is the power is with the caste verification committee to cancel the caste certificate. Other assistant commission, that is one round. Second round is that it is only the complaint submitted by DCRE shall take steps in present such way which was obtained of our.
So the further submission that the FIR registered on the basis of the anonymous letter is also without authority of law.
The authority specified to take steps for prosecuting the petitioner rest with the Directorate of Civil Rights Enforcement as specified under Rule 7A of the rules. Hence, it submits that the impugned order passed by the second respondent and shows that the registration of the FIR by the jurisdiction police is one without authority of law. On the other hand, learned SCGP appearing for the respondent state submits that the petitioners having obtained the caste and income certificate by on the basis of by making false representation, the impugned order passed with the second respondent, cancelling the caste and income certificate issued in favor of the petitioner, as well as the registration of the FIR against the petitioner or by the jurisdictional police is justified, and the same does not warrant any interference. I have examined the submission made by non-counsel to the party. Mr. Bandari, just see that the caste verification. No, answer. ಏನಂತ ಇದು
no direction is given to the police to investigate the matter. In case if any verification is impaired to verify the as a candidate, this health verification will just conduct the inquiry. And then also for the decision where of the unlimited data and this court in identical circumstances observed that if there is any verification as gas verification just go into the matter and find out the gas and not
Yeah, ಗೊತ್ತಾಯ್ತು ಇದ್ರೊಳಗೆ now that an order is passed by the assistant commissioner saying that by misrepresentation you have obtained the caste certificate. That order is without authority of law because the authority is the authority which has got the power to cancel is the verification committee, caste and income verification committee. And the second ground is it is only the Directorate of Enforcement who can lodge a complaint and not on the basis of an anonymous letter. All right. 17th. For the dictation. Yes, Mr. Karambay. In case of theft, case of theft. ಇಲ್ಲ 400 420 ಅಂತ ಮಾಡಿದ್ದಾರೆ. ಚೀಟಿಂಗ್ ಹೆಂಗ್ ಬರುತ್ತೆ? ಚೀಟಿಂಗ್ ಇಸ್ ನಾಟ್ ಅಟ್ರಾಕ್ಟ್. ಚೀಟಿಂಗ್ ಬರಲ್ಲ. Or not take. ಇಲ್ಲಿ ರಂಗರಾಮ್ ಇಲ್ಲ. No representation on behalf of the petitioner. List this matter on 17th.
Here for the petitioner. Lord, yes. The proceedings not initiated under the Domestic Violence Act as against my brother-in-law.
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 How? Brother-in-law. Lord, what has happened is, Lord, the respondent, Lord, and my brother got married in 2009.
Sriranga is in next in portal number 1.
Lord, permit me to, Lord, complete my submission. Lord, he can reply some other day.
No, on this small matter.
Lord, the petitioner, Lord, is working, Lord, as a civil judge. But he is made, Lord, to undergo, Lord, this process only because, Lord, he is occupying the post. Settle agate. Lord, the domestic violence case, Lord, if in effect,
they're not residing in the same house.
No, Lord. Okay. That's all the issue, Lord. Even the claim that she has sought for is for compensation, Lord, that she has sought for against my brother. Let her pursue the case against my brother. I have no objection.
Yes, Mr. Sriranga. He is not residing in the same house. He is a civil judge. Our ಮೇಲೆ ಇದು ಮಾಡಿದಾರಲ್ಲ.
This episode happened around the time he was giving
whether is it a case he was residing in the same house?
I mentioned it to be so. And what has happened is my entire house in my absence is shifted to his house. Therefore, allegation not in document production, entire thing, including not all belongings.
The incident occurred when he was a judge or
just before that. when not he was on a training, then not it was shifted. Allegation not is he was while he was practicing in Mysore, he was staying here not in Bangalore on all weekends. And not there are allegations not of harassment and loss of property which has been caused. That's the allegation.
The settlement ಆಗುತ್ತೆ.
ಅದು mediation ಗೆ ಹೋಯ್ತು.
Mediation ಬೇಡ, will not send him to mediation. They are only settle the matter. Yes, one more.
We were open, Lord. Matter was referred to mediation. In fact, I even, Lord, we had discussion with Mr. Sriranga. But
Not send the petitioner to mediation center, but our settlement, you put it across. Record it and dispose it of.
now, Lord, he, in fact, even they have a divorce, Lord. My brother and Lord, the respondent. Now there's a divorce, Lord, passed, Lord, against the respondent. The divorce decree has attained finality. ಕೆಲವು findings with the
allegations are common against the petitioner and the brother.
ಅದೆಲ್ಲ ರಿಸಲ್ವ್ ಆಗಲಿಲ್ಲ. ರೈಟ್, ಒಂದು 4-5 ಲಕ್ಷದಲ್ಲಿ ಒಂದು ಆಫರ್ ಮೇಡ್ ಅಂಡ್ ಇದು ಆಮೇಲೆ ಅದು ಪ್ರಾಪರ್ಟಿ ನೆಗೋಸಿಯೇಷನ್ ರೇಟ್ ಮೇಬಿ ನಾಟ್ ಎಂಟರ್
In whether your client is ready for settlement.
They had given some offer, Lord, but her expectations are too high, Lord. I don't think, Lord, it will work out.
Religion expectation ಮಾಡಕ್ಕಾಗುತ್ತೆ. The marriage and with
but marriage took place on 27/8/2009. Lord, both were, Lord, in the US. The respondent and my brother, Lord, they were, Lord, in US up till, Lord, September 2014. That is when they came back to India. And then they were residing together, Lord, in Bangalore. The respondent separated from my brother, Lord, in July.
Cruelty ಒಳಗೆ it has been decreed. Marriage has been dissolved. Attained finality. No, but the very same allegations have been, no, the very same allegations were the subject matter of the divorce petition. ಅಲ್ಲ ಎಲ್ಲ ಅದ್ರೊಳಗೆ ಇದೆ ಅಲ್ಲ ಬಂದಿದೆ ಅದೇ husband same common allegation all are common allegations. It may not be binding, but it is relevant under section 41 to 43 of Indian Evidence Act. ಏನಾದರೂ ಸ್ವಲ್ಪ whatever just Mr. Manmohan, make some offer, reasonable offer and close it.
I'll ask them again, Lord. Because even she is working, Lord, she is doing well. It's not as though, Lord, but he has offered, but ಅವಳು ತುಂಬಾ ಕೇಳ್ತಾ ಇದ್ದಾಳೆ. They are not ready to pay that. Because her education, Lord, all, Lord, the
is a civil judge.
Against, Lord, my brother, let it go on, Lord. He's
this
not.
The Domestic Violence Act is filed against the petitioner and the husband.
Yes. Petitioner and husband and father-in-law. No, my father is no more. My father also made a party. My mother also was made a party. ಎಲ್ಲರನ್ನು ಒಟ್ಟಿಗೆ ಹಾಕಿದೆ. Let her proceed against my brother, Lord. I have no objection, but insofar I am concerned, Lord. She filed a complaint before this honorable court also, Lord, against
an
me.
order by the family court dissolving the marriage on the ground of cruelty. This petition, this proceedings will not stand. So advise your client to take some money and buy peace.
Lord, she filed a complaint before this honorable court, Lord, against me. Lord, that complaint also, Lord, was closed by this honorable court, Lord. I have produced that also on record.
Yes, Sriranga, otherwise I tolerate. Because that order dissolving the marriage has attained finality. It may have relevancy to decide. Though not binding on in a criminal matter, it has got relevancy under section 41 to 43 of Indian Evidence Act. Yes. When do you want one more?
Lord, 17th, Lord.
17th.
Great.
Yes.
But the petitioner, my lord, is a police officer. The petitioner, my lord, is a police officer.
Mr. Shyam Sundar, Learned CGP is praying for time, saying that is not ready with the matter.
Agboth, my lord, say short date may kindly be fixed, my lord. His promotions, my lord, are held up. My lord, what happens, my lord, in one line, my lord, if I may, my lord, put the case across. Now, my lord, a police officer, my lord, was discharging his duties. Now, my lords, a police party, my lord, would go to serve a warrant upon, my lord, an accused person. The accused, that accused person and, my lord, his mother, they would, my lord, brutally attack the police party, set, my lord, the vehicle of the police party on fire. Only one, my lord, pictures, my lord, I have produced also, I had also placed, my lord.
What is the FIR registered against the petitioner?
The FIR, my lord, is registered against.
It is private complaint, huh?
No, my lord. It was, in fact, my lord, they were investigating, an SP was investigating, my lord, a cause of death. SP would go to the jail, and by taking a complaint in the jail from, my lord, a lady who was accused and who was detained inside the prison for attacking the police party, my lord, this complaint came to be registered, where, my lord, the officers, my lord, who were on the duty on that day, my lord, they were all arrayed as accused persons. Only one document, my lord, which I would, my lord, humbly show. Kindly, my lord, have page number 192.
Yes.
Now, my lord, I have also produced a videograph, my lord. These are the still pictures. Now, my lords, may kindly see the kind of, my lord, resistance, my lord, this person would offer. And, my lord, on page number 193, the person, my lord, deceased, and, my lord, his mother, both of them, my lord, would set the police party, my lord, vehicle on the fire, and, my lord, they would attack the police personnel. And, my lord, with the help of the villagers, they were somehow, my lord, surrounded. And when he was being taken to, my lord, police station for, my lord, booking action under law, he would, my lord, develop heartache, and, my lord, he would die of, my lord, coronary, my lord, syndrome. My lords, may kindly have page number 271, my lord, the doctor's report. The government doctor, my lord, would examine the cause of death, and, my lord, would opine. My lord, on page number 271, the last paragraph, my lord, the final cause of death. On perusal of the above mentioned documents, we are of the opinion that the final cause of death is due to the myocardial bridging, which is with coronary spasm. That is natural. My lord, even the word, particularly the word natural, my lord, is put. Now, my lord, he dies a natural death. Now, my lord, they would book, my lord, a case as custodial death, and, my lord, would array all the police officers, my lord, who took a challenge on their lives, my lord. They were trying to implement the law, my lord. If this was, this is, my lord, the approach.
Death is not in the custody.
No, my lord, when he was being taken, he attacks, my lord, police party with the help of, my lord, villagers. My lord, even the pictures of all the villagers, my lord, surrounding and apprehending him is also seen in the photographs. With the help of villager, he was, my lord, somehow, my lord, arrested, and he was apprehended.
To execute warrant in which case?
I beg the pardon, my lord.
You said that when they went to execute warrant against Devraj.
They went to execute a warrant, my lord, in respect of a 125 case, my lord. I have produced the records of that also, my lords. May kindly have page number 42. This person who the wife of the deceased person had filed, my lord, a case of, my lord, violence against him, and, my lord, she had filed a case of, my lord, maintenance, etc. He was not appearing to the court, and, my lord, the jurisdictional court would go on issuing warrants. Finally, my lord, they were strictly directed to implement the warrant against this man, and the police would go to serve this warrant. When they go to serve the warrant, the mother of, my lord, the deceased, who is still in custody, and, my lord, this person accused, the person deceased, who was also an accused in that case, they would attack the police party. And, my lord, with the villagers' help, my lord, somehow the police would, my lord, overpower, and, my lord, he was being taken to, my lord, to the nearest police station. He was also taken to the nearest police post. There, my lord, he would complain, and he was immediately taken to a local hospital. With the local hospital, the local doctor suggesting that he appears to have developed some heartache. He was taken to, my lord, the government hospital. There, my lord, he dies. My lord, what is attributed is custodial violence. My lord, this is absolutely false. My lord, a glaring case, and my lord, they would register, my lord, a case, a prosecution proceedings without, my lord, the sanction, which is a must, my lord, as required, my lord, as under section 170 of the Karnataka Police Act.
No, that is the charge sheet is filed.
No, my lord, the proceedings, my lord, are now stayed by, my lord, an interim order passed by this honorable court.
Action can be taken at the time of filing of charge sheet also.
No, that's section 170, my lord, of Karnataka Police Act. 397, my lord, yes, it could be, my lord, even at the time of filing the charge sheet. But, my lord, 197 CRPC, my lord, it could be even at the time of, my lord, filing charge sheet. But 170, my lord, suits or prosecution in respect of acts done under the color of duty aforesaid not to be entertained without the sanction of the government. In any case of alleged offence by the commissioner, magistrate, police officer, or reserve police officer, or any other person, or a wrong alleged to have been done by such commissioner, magistrate, police officer, or reserve police officer, or other person, by any act done under the color in exercise of any such duty or authority as aforesaid, or wherein it shall appear to the court that the offence of wrong is committed or done was of the character aforesaid, the prosecution or suit shall not be entertained. My lord, the word employed, my lord, is entertained. My lord, in the Rastriya Rifles case, as my lords are kindly aware, my lord, the Honorable Supreme Court, my lord, would go into, my lord, the aspect of institution. Even institution, my lord, is prohibited without the sanction. My lord, otherwise, my lord, there would be no protection, my lord, to the law enforcement officers at all. Even entertainment of a complaint, my lord, is prohibited.
Consider. Yes, Mr. 2 weeks.
Interim order may kindly be continued.
Interim order ilva?
ಇದೆ ಅದು ಕಂಟಿನ್ಯೂ ಆಗಬೇಕು.
At request of learned SCGP.
Promotions ಎಲ್ಲ ನಿಲ್ಲಿಸಿದ್ದಾರೆ. My lords may kindly fix the date, my lord. I will finally argue them.
At 22nd, interim order granted earlier if any is extended until further order. Yes, 22nd will dispose it. Grateful. 22nd. More representation, that's the matter of 10 days.
68, my lords.
Yes, 68.
68 and 69. 68 and 69, my lords, I seek a week's accommodation. It's because one of the respondents filed some objections. I need to verify from the BBM developments.
That's the matter of 1 week. 68 and 69.
The date may be fixed, my lord. There is some because they have been retired. They have been waiting for their pensionary benefits also.
22nd.
Much obliged.
22nd has some inconvenience. 21st or 21st.
17.
Yes, ma'am. 17. Yes.
At that time, it was pointed out that there is a pending suit. Direct single judge is not required to
Yes, Mr. Venkat Reddy, bill number 70. Again, 15th. WP. No representation on behalf of the petition. This matter on 16th.
Serial number 71.
I beg to pay for the petitioner, my lords. My lord, he has taken time, my lord. It is a case where, my lord, ultimately they have filed 511.
Yes, sir.
511 ಮಾಡಿದ್ದಾರೆ. They started with saying, my lord, that PSI exam question papers have been leaked. And my lord, someone has been going to make use of it, and that ultimately nothing was seized. The examination was conducted as usual. There was no leakage of question papers. And ultimately, they have added matter 511. The name of the petition doesn't appear in the complaint. Nothing is seized. He attended the examination as usual. He failed. Absolutely no, my lord, overtract attributed to this. Nothing is seized.
But due to my pandemic, there is still effect.
Last time, my learning government took time to file objections.
Unable to get them, but some of the
511 attempt ಮಾಡಿದ್ರು ಅಂತ ಹೇಳಿ. He appeared for the examination. He was issued with hall ticket. And in the complaint, my lords, only accused 1 to 8 names are there.
24th. Yes, sir. He wants time.
My lord, his promotion is, my lord,
Promotion.
promotion ಅಲ್ಲ, ಡಿಕ್ಲರೇಷನ್ ಮಾಡಿಲ್ಲ ಅವ್ರದ್ದು. ಇದನ್ನ ಪ್ರೊಬೇಷನ್ ಪೀರಿಯಡ್ ಡಿಕ್ಲೇರ್ ಮಾಡಲಿಲ್ಲ. He is on duty as on today. His suspension was revoked by the department.
First of all, CGP left this matter on. Sir, when do you want, sir?
Any, my lord, urgent this thing, because he is on duty as on today as police constable.
22nd. 24th. Final interim order granted earlier. Then is extended until further order.
Yes.
Yes. Oh, you are.
Lord, appearing for the petition in the corrected matter, my lord.
Yes.
My lord.
What?
Now what happened, my lords? Unfortunately, my lords, my meeting is carrying, my lords, 2 villages. One village panchayat has issued toll number. Other panchayat is contesting. Yes, that of record numbers. Other panchayat is already, my lords, added toll numbers to my duties.
ಯಾರು ಸಚಿನ್ or PP ಹೆಗ್ಡೆ? Yes, you
appear for PP Hegde, my lords.
Yes. Ready, na?
My lord, short accommodation, my lords. Senior is held up in other court hall. Any date in the next week, my lords?
The interim order granted by this court, my lords, now they have given electricity connection. NOC to not only one panchayat so far.
Why is it refusing to give assign for door number?
Door number, they say, my lords, one pillar of my building is, my lords, may come in future, my lords, in the not now, in future. Road agala ಆಗುವ ಸಂದರ್ಭದಲ್ಲಿ ನಾನು ಹೋಗ್ಬೋದು.
Because of not transfer respond number 1, list this matter on 18th.
Much obliged. My lord, one more submission, my lords. My name may kindly be shown instead of my senior's name, my lord. Venkatesh Somareddy, my lords.
Office to delete the name of PP Hegde and associates and reflect the name of Venkatesh Somareddy as counsel appearing for respond number 1 in unconnected matter ಒಳಗೆ petitioner 72.1.
Much obliged.
In this case, I appear for the petitioner, my lord.
Gautam.
Please, my lord, I appear for the respondent, my lord. Matter may be called next week, my lord. Next week, my lord.
It is a very short matter, my lord. Annexure E prakar. They are putting up a.
Then will file objection. Then he has to file objection.
Please. Last time ತಗೊಂಡಿದ್ದಾರೆ ಅವರು time for filing objections.
Current counsel for respond 1 to 3. When do you want?
Week, my lord. 10 days, my lord. 10 days.
My lord.
21st.
Please, my lord. Indeed. Please.
Now, may I make, my lord, one submission? Yes. 71, my lord. 21st ಹಾಕೋಬಹುದಾ?
The 21st, not 22nd. 22nd. Number 71.
Click on the screen. 76. Serial number 76. The state.
We have to consider 76.
Second respondent is contesting.
Mr. A.V. Gangadharappa. How can they consider this representation? You tell to remove the encroachment on your land by the corporation. ಅಲ್ಲ ನಿಮ್ದು ವಿಷಯ ನೋಡಿ ಅಲ್ಲಿ ಶಿವಮೊಗ್ಗ ಜಿಲ್ಲೆ ಕಾಲಿನ ವಿಷಯದಲ್ಲಿ ಒತ್ತುವರಿ ಮತ್ತು ನಮ್ಮ ಕಾಲಿನ ವಿಷಯಕ್ಕೆ ಹೋಗಿರುವ ದಾರಿಯಲ್ಲಿ ಕಾನೂನು ಬಾರಿ ಮನೆ ಕಟ್ಟಿರುವುದನ್ನು ತೆರವುಗೊಳಿಸುವ ಬಗ್ಗೆ. Under what provision of law? Encroachment care ಮಾಡಬೇಕಂದ್ರೆ ಕಾರ್ಪೊರೇಷನ್ ಆಕ್ಟ್ ಅಲ್ಲಿ is there any power for the commissioner to remove the encroachment on your land? Yes, madam.
My lords, they have also approached the civil court. If my lord sees the representation, they already have an order in their favor. They have to go get it.
For the civil court. Execute ಮಾಡ್ಬೇಕು ಡಿಕ್ರೀಸ್ ನ ಇದು. ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ ಮೇಡಮ್. 1 week's time is there. This matter next week. On date good. 18th madam.
Grateful.
Vendors are one and the same. The only purchasers are different. Further, it shows that there are no two certain villages. It is Chaknati village, Marenalli Dakle. That is what is reflected in the sale deed, which is referred to in the 2005 sale deed also. Even in 1995 sale deed is reflected as the same. Course of title is the
same. Your lordship's permission.
Yes, yes, sir.
Can you circulate the judgment of justice? Could not your lordship tomorrow morning?
Yes, sir. I got it, sir. Has been placed before me.
Much obliged. Deeply obliged.
From 17 years, I have got it.
Serial number 83, my lord.
83.
83, my lord. Last date of hearing, my lord, at the request of the government advocate, my lord, time was on.
You know the 83.
But it was regarding infringement of not certain copyrights. It is a case that has been lodged. Not is that certain respect of certain movies, not CDs have been not created. On the other hand, it is my specific case that there was already a civil suit before the party with respect to the same parties. Court has already given a finding. In spite of that, they say that I am not entitled to not make use of those agreements which have been executed in my favor. For
It is under what provision? 143, 147. ಇದಲ್ಲ ಮೇಡಮ್ 83.
interim order is in operation till today.
As this matter on 17th. On 17th, interim order granted earlier if any
Serial number 70, your lordships.
Yes, madam.
I appear for the petitioner in this matter, lordships. The respondents are yet to file objections in this matter.
Madam. 16th.
The government advocate may be directed to kindly file.
16th, madam.
Please, obliged minds.
Pass over matter, my lord. Serial number 17, my lord.
79. Next. 17th.
17, my lord. 17, my lord. 17.
22nd. 22nd. Interim order granted earlier until further order. Serial number 17, madam. 96. Madam, on short brief. 70, 96. 96, madam. Serial number? 96.
Lords, with my lord's kind permission, serial number 93, my lords, if my lords could extend the interim order, there's an interim order in force, and my lords, a date may be given.
Yes. 93 order, wherever interim order extended till the next date of hearing, all matters.
My lord, serial number 87, my lord. I am for
Yes.
respondent number 3, my lord. Any short date may be given, my lord.
Yes, sir. 17 or 26.
Serial number? Serial number?
Serial number 87.
Respond number 3, my lord.
21st. 22nd. 22nd.
My lords, a date for serial number 93 also, my lords, if my lords permit.
17th.
17th. 17th.
Grateful, my lord.
My lord, 17, my lord, serial number 17, interim order
17, yes,
today, my lord.
17.
My lord, short point arises, my lord, it is non-compliance of the Priyanka Srivatsa case.
Again, it has to be remanded.
My lord,
Remand ಮಾಡಬೇಕು.
my lord, Priyanka Srivatsa case, they have not complied, my lord, affidavit has not been filed, and also the demand is for repayment.
Matter will be remanded after setting aside the order. Securable defect.
My lord, no order has been passed, my lord. No order has been passed. Only they have registered an FIR under section 154. Before approaching the court under 200 CRPC, my lord, 154 subclass 1 and 3 has not been complied. Only to harass the petitioner, my lord, they have filed the complaint before the trial court. The trial court, without considering, without going to the material record on the evidence, my lord, they have referred the matter to the police under section 156 subclass 3.
Yeah, it has been cost.
Even there, I have deposited 1.5 lakhs. I have deposited before, my lordship. Their prayer is for money. I have deposited that money. In spite that they are not.
Before this court.
Yes, my lord. I have deposited 1.5 lakhs. Before this court only, I have deposited on 21/10/2019. I have deposited.
Have you got any objection for permitting the respondent number 2 to withdraw the money?
I have no objection. For them only, I have deposited. I have no objection. Their prayer is also for payment of money. Because of pendency of this case, they are publishing the bad news against me, my lord. I have taken their money.
The second respondent filed a private complaint under section 200 of CRPC against the petitioner, alleging that. What is the allegation?
Allegation is that I have not given the site for the amount which they have deposited in the 2007.
The petitioner has not allotted the site to the petitioner, to the complainant, though having received the sale consideration amount of rupees 1,50,000.
Yes, my lord.
1,50,000. The jurisdictional police referred the matter to the police for investigation under section 156C of the Criminal Procedure Code. Being agreed by the same, this petition is filed. Foreign counsel for the petitioner submits that the private complaint filed by the petitioner or by the complainant is for the offences punishable under section
417, 420, 506 IPC. 417, 420, 506.
417,
420,
506, 420, 417 of IPC, which are cognizable and non-bailable. Hence, the complaint is in the private complaint. However, the second complainant has filed the private complaint
without compliance of 154, 1 and 3 of CRPC.
Of section 155,
54, 1 and 3 of CRPC.
Without complying section 154(1) and 154 of CRPC. Hence, he submits that the cognizance take. Hence, he submits that the order passed by the learned magistrate referring the matter to the police for investigation requires to be quashed. On the other hand, learned SCGP appearing for the respondent state would submit that the learned magistrate has rightly referred the matter to the police for investigation under section 156 of CRPC, having regard to the fact that the allegations in the complaint discloses the commission of the offences alleged against the petitioner. I have considered the submission made to the learned counsel for the party. The result of the complaint discloses that the allegation in the complaint is that the petitioner, having received a sum of 1,50,000, has not executed the sale deed in favor of the complainant in respect of the plot in question. Plot either?
Yes, my lord, plot.
So the offences alleged against the petitioner is cognizable and non-bailable. However, the complainant has not disclosed in the complaint or filed an affidavit stating that after complying with section 154(1) and 154(3) of the CRPC, the present complainant said, the apex court in the case of Priyanka Srivatsava reported in so and so. Then I held as follows. In view of the ratio enunciated by the apex court in the case of Priyanka Srivatsava, the complaint filed by the second respondent without complying section 154(1) and 154(3) of the CRP is not sustainable in law. Accordingly, I pass the following. Criminal petition is allowed. The proceedings
In PCR number 319 of 2019 on the file of JMFC Police at
on the file of Civil Judge, Senior Division and CGM Court at Shira, Tumkur District, registered for the offence punishable under section 417, 420 and 506 of IPC is hereby quashed. Liberty is reserved with the second respondent to withdraw the sum of rupees 1,50,000, which is deposited by the petitioner in pursuance of the order dated
21/10/2019, madam.
Subject to the second respondent furnishing proper identification. Even having regard to the fact that the petitioner has deposited the sum of rupees 1,50,000 alleged to have been received by the petitioner from the second respondent, it would be appropriate and the complainant having sought for refund of 1,50,000 from the petitioner in the complaint filed against the petitioner, it would be appropriate to so as to secure the ends of justice, and it would be appropriate to quash the interim proceedings.
Hello, 79 mallards. I'm sorry, I was not there.
Yes, yes.
79 mallards. I was.
It is urgent, sir. It is urgent.
Yes, I'm sorry, mallards, I was not there. Mallards.
Madam,
79 ಏನಾಯ್ತು? Court of sir. Madam, court of sir.
22 sir, 22.
22 ಹಾಕಿದಾರ 79?
ಹೌದು ಸರ್.
ಅಲ್ಲ 79.
22 ಗೆ 79.
ಆಮೇಲೆ 72 71 22 ನಾ
ಸರ್ ಒಂದ್ ನಿಮಿಷ ಇರಿ. 71 ಅಲ್ವಾ ನಿಮ್ದು?
71 and 79.
22.
72. Yes, madam.
ಇನ್ನೊಂದು ಯಾವ್ದು ಸರ್ ನಿಮ್ದು?
87 ಮೇಡಮ್.
ಅಲ್ಲ ಒಂದ್ ನಿಮಿಷ. 72 and 79.
72 on 79. ಸರ್ ಒಂದ್ ನಿಮಿಷ ಹೇಳ್ತೀನಿ. 79.
Further hearing matter.
79 22 ಎರಡು ಒಂದೇ ದಿವಸ ಸರ್.
ಎರಡು ಒಂದೇ ದಿವಸ ಹಾಕಿದ್ದೀರಾ? ಓಕೆ ಪ್ಲೀಸ್ ಥ್ಯಾಂಕ್ ಯು.
ಮೇಡಮ್ ಸ್ವಲ್ಪ 82 ಹೇಳ್ಬಿಡಿ ಫರ್ದರ್ ಹಿಯರಿಂಗು. ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್